look at this, look at that. If this is the position, is it a case, Lord, of discretion under 482? Is the ultimate question. If your lordships feel that all this is bunkum, then your position is different. But if your lordships feel that there is material, there is an FIR, doesn't deserve to be quashed, no tender, done without tender, all this, Lord, your lordship will see.
At present, we are not.
Correct. So I'm only saying, Lord, prima facie, these facts persuade the court not to exercise 482. That's not the ultimate bottom line of a lordship's discussion, whether it's 226, whether 482. This is how, Lord, it will go. This is how this will go. That ultimately, Lord, the judicial conscience of a court will be shocked by the material placed on the counter affidavit. And therefore, Lord, it is not a case of 482. And Lord, my friends have not argued what is wrong with the High Court. High Court has answered, High Court has gone with two issues. One is Lord 17, by saying Lord, it started in June and all that. And also, Lord, is a case of official duty. And these are the facts in this case, and therefore it can't be so. So, what is wrong with that? We can't argue Lord every case saying the Supreme Court should become a court of first instance. Unfortunately, Lord, I am also equally guilty. We argue it here like this.
Good to hear from you.
Yes.
On this side.
Lord, and I'm saying so, Lord, I admit.
Tomorrow you'll be on this side.
I agree, but Lord, somehow this tendency has occurred. You can't crash the judgment of the High Court unless, Lord, somebody says what is wrong with the High Court.
Yes, Mr. Salman.
So Lord, just borrow two. Now, Lord, borrow two things I wish. But just now note Niharika. The judgment of this court, Lord. Justice M.R. Shah speaking. Niharika. I have, first Niharika. Niharika, my Lord, is a judgment of this court in the additional compilation.
Justice M.R. Shah.
Yes, very important, Lord. Only conclusions I will.
Yeah,
So, judge bench, very exhaustive judgment on 480.
which
Lord, in the second compilation, additional judgment compilation. It is titled additional judgment compilation. Additional judgment loss. Lord, in this, the Harika is item 9, page 152. Lord, a three-judge bench. And I want your lordship only to see the conclusions. That are very, very detailed. The conclusions are, Lord, in respect of 482 petitions and the interim orders to be granted therein. That, Lord, is para 80 and 187. So it is, Lord, for all situations, whether interim orders, whether final orders, whether it should be entertained, not entertained, etc. Now look at the conclusion in bold. And bold is not mine, Lord, bold is the print of the judgment. Right. Lordship looks at the conclusion. Police.
Here everything is permissible. In lower courts it is not permissible.
Sorry.
Here in Supreme Court everything is permissible. In lower court this is not permissible. If you highlight anything,
Right.
that amounts to.
Here,
No.
Lord, the Supreme Court is highlighting.
That's what I'm saying.
What is
That amounts to influencing the judge.
But we have not highlighted.
That's what I said.
Nonsense. It's permissible in Supreme.
Well, let's go to the conclusions. Police has statutory right and duty under the provisions of CRPC contained in chapter 14 to investigate into offences of offence. This is not, in our case, this is the position. Courts will not thwart an investigation into cognizable offences. It is only in cases where no cognizable offence or offence of any kind is disclosed in the FIR that the court will not permit an investigation. This is a restatement of Ajala. This is the restatement of Ajala. Can you say from the FIR that there is no offence? There are 10 offences under the IPC. He only talk about 17. What about those IPC offences? Where do they go?
Has to see the context also. See, under 17A, the statute itself says that no investigation, inquiry shall be.
That's all
So
right.
in that case.
But that is,
so
but that is,
Yes, in normal course, yeah.
your 17A says, PCI. What about non-PC? What about non-PC at the end of the day? Anyway, so your power of C4, power of quashing should be exercised sparingly, circumspectly, observed in the rarest of rare cases, not to be confused with death penalty. While examining an FIR, quashing which is sought, the court will not embark on an inquiry as to reliability or genuineness of allegations made in the FIR. If this can't be examined, that without what he did was not in judicial, without course of public duty, then that is how it is. And our case is only of money, beloved. It's not a case of some proper decision. It's a case of misconduct for money. That's our case. Then, beloved, see, beloved, item 6. Criminal proceedings ought not to be scuttled like initial. Quashing of a complaint will be an exception than the rule. Ordinarily, the courts are barred from usurping the jurisdiction of police is to order the state operating to fair.
Mr. Rohan is fundamentally same as Bhajan Lal.
But we are more detailed. And if I say so, we are a little more strict and a little more. That's why I will show you. Items, item 8, item 9. Function of the judiciary and police are complementary, not overlapping. Save in exceptional cases. See how many times the Supreme Court has restated the decision in different words now. Save as exception, save when no unfair without miscarriage. The court and judiciary should not interfere. It's a restatement for the same principle. See, in our extraordinary power, do not confer arbitrary jurisdiction to the court to act according to whims. The first information is not an encyclopedia, which must disclose all facts and details. Therefore, when investigation is in progress, the court should not go into the merits of the allegation. Police are permitted to complete the allegation. It will be premature to pronounce conclusions based on daily facts that the complainant does not deserve to be investigated or amounts of abuse. After investigation, if the IO does not find that there is no substance in the application, investigate on the file of a police service. Power under 482 is very wide, but conferment of right power requires the court to be most cautious, asked in honor and more diligently. However, at the same time, the court will things without being held in the body. Self-restraint is good law, no permitted by the legal in Kapoor and Bajala at the jurisdiction. So, therefore, caution is made by the alleged accused the court when it says power and court. One has to consider, only has to consider whether allegations are filed disclosed commission. Court is not required to consider the merit, whether or not the merits of the allegation before the parliament case. And the court has to permit the investigation. Agency to investigate. The aforesaid parameters will be applicable. And forces are required to be considered by the High Court while passing it into more than the Washington. Maybe that will go on about interim order, etc. But I only wanted the Lordships to note one more judgment. But the Lordships will know, and we come back to the first compilation. Come back to the first compilation. The first judgment is called State of Rajasthan versus Tejmal, a judgment of this court, which says, Lord, Lordship can note on the side, the judgment of this court says that 7 is not merely procedural. But it is settled law, not procedural applied retrospectively. Procedural applied, but substantive does not. Question arose whether 17A is procedural or substantive. So sometimes you have a hybrid. Some part is procedural, some part is substantive. If that is so, then 17A will not apply retrospectively, and therefore on my first submission that it will not apply at a time when it was not born. This is the affirmation of that position.
No, but the argument has been placed in a slightly different way.
Yes.
That 17A prohibits certain action by the prosecution at a given point of time. Now, the offense may have occurred or taken place at an early date. But when you are going to take action in pursuance of that offense, already this
has come.
This has come.
Yeah.
So, to that extent, even if we treat it as prospective,
Yeah.
that bar might, that is the argument.
So to that, my respectful answer is, that's why I give your lordship the chapter 1 and chapter 2 arguments. 17A came in, my lord, in June 2018, or July 2018. I have divided it into two parts, pre-July 18 and post-July 18. It is my case, and I showed you judgments, that, my lord, what an offence is occurring at a particular time, in this case prior to July 18, will be tried by the law then obtaining, and therefore C and D will also apply. Therefore, 13(1) C and D will also apply, which have hitherto, my lord, later been removed. Therefore, when 17A was not born, notwithstanding, my lord, the FIRs of 21, but it is for investigation into offence of 2015, at which point of time 17A was not there, and 17A, my lord, not being, my lord, procedural, will not apply in the judgment of this court. That, my lord, is the first judgment. Just a second.
You are narrowing your argument here that so far as 13(1) and D are concerned,
Yes.
first of all, they'll apply so far as
The
the
offence is concerned.
offense is concerned.
Right.
And because 17A was not there at that point of time,
Yeah.
17A would not apply.
Because it's juxtaposed, my lord.
That is your
C and D was there. My lord is right. 13(1) C and D were on the statute book in 2015-16, and therefore, my lord, by virtue of Article 20 of the Constitution, the man will be tried for the offences as per obtaining law at that time. That is not the mandate of Article 20. And in the same tone, my lord, I submit that what was not there, unlike CND, what was not there in 2015-16 will not apply, because 17A has been held by this court not to be purely procedural. It has been held, my lord, it is procedure, but it has substantive rights also within that procedure. Some are pure procedure, pure substantive. May I give you lots of
that is that Garikapati.
Correct. It starts from there.
Yes.
You know, let me give you lots of a simpler example. A right of appeal. It is settled law that a right of appeal is a substantive. So the moment a suit is filed in law,
That is Garikapati.
Right.
So what was the
what was the position obtaining for an appeal on the day when you file the suit? Because suit and appeal is a continuation. So if I file the suit today, a first appeal under 96 is available of CPC. If it is taken away after 3 years pending the suit, it will make no difference because the appeal will lie. That is pure, my lord, substantive. But take a case, my lord, where an appeal can be filed in 3 months, 90 days. That 90 days is reduced to 60. That has been held to be purely procedural, because that is not, my lord, something so great. You can file an appeal, you have a right of appeal, file it. But you file it, my lord, within 60 days. That is, my lord, procedure. But here,
no, but if the amendment comes on the 62nd day, what will happen?
sorry,
If that amendment
Ah.
reducing the time to file appeal
yeah.
comes on 62nd day,
Then, my lord, his right has been saved. But otherwise, there his right will be saved. Because he can't be taken by survey. There the right will be saved. But otherwise, if you are ongoing and your right to appeal is after a long time, then 60 becomes 90 or 90 becomes 60, that really makes no difference. But the right to appeal is substantive. So this court has held in law that 17, if it's a kind of hybrid, it has substantive issues within it by giving protection and an obligation of the department. It does two things, brother. It's some kind of protection and also an obligation on the parties. So that is not purely procedural. It's a kind of a hybrid, and therefore it will not be purely procedural, and therefore will not be. They seem to be claiming 17 as a matter of right. 17 is not a protection for the if I may use the phrase, for the persons who commit misconduct. It's not a
But at some point, my bloody friend will finish work. It's 3 o'clock now.
so right court is still 4. Now, I gave a lordship of judgment.
You plan to go until 4 o'clock, Mr. Rodgi?
I don't know. Therefore, my lord, therefore,
What? This is not fair.
have a time frame.
no, my lord, I'm finishing.
Some discipline of time, my lord.
Anyways, now nothing is.
My lord had said today.
There is something else. 5 more minutes I wish to.
We
By 5-10 more minutes.
conclude the hearing in this part of the.
Yes, yes, 10 minutes and finish. My last point. Would you not see this page?
I have my other petition is also pending after this, not the other one, item 3.
Yes.
Yes. Would you not see?
Mr. Salve, within half an hour,
Yes, half an hour.
half an hour.
Because I want to leave half an hour for Mr. Luthra for the other matter.
Difficult for us to sit beyond sports.
Yes, of course, yes.
No, because Mr. Luthra's matter is also there. That's why my friend, I mean, he has gone on for 4 hours. I
Post
think
it maybe some other day.
So this one can,
I want 10-15 minutes.
So what, no, you have covered
he
all.
started with 5, then 10, now 10 has become 15.
What we can do, we don't want to curtail you, but we want to finish early. Maybe day after also at 2 p.m. we can post these matters.
My learned friend wanted half
In
an
the
hour.
event you,
He has
you
taken 1 hour.
no,
in my turn, my matter.
this matter.
Both matters.
This matter, I think this matter for 10 minutes and Mr. Salvi is there, he's saying conclude. Please ask Mr. Salvi.
More than half an hour.
Then
Okay, so then.
So 10 minutes,
Another
Let's
matter.
finish this part, his.
then
matter
my
will
turn
go
will come.
The other matter will go here.
but then
Let us see, my lord, how long I take. Let
your
us finish in
advice
10
to
minutes.
your client will have to remain till day after tomorrow.
But let the other matter wait,
When I
I
made a
have no
statement-
difficulty.
When I made a statement,
Let the other-
it must continue till we not.
So, Mr. Luthra,
Friday,
we will finish it today.
yes, Lord.
Your matter will take day
Friday,
after,
Friday.
day after,
Friday,
Friday?
Friday.
Okay, Friday,
Whatever.
Friday, fine.
The Lordship will not just have.
So 1 minute.
And the same understanding will continue.
We'll pass an order.
Like item 3.
Let it be on Thursday.
Item 3,
I may have some difficulty, but I'll do it on VC then. That's the only problem.
Thursday,
Then I do it on VC. I may have some difficulty. I do it on VC then. Friday if possible, Friday if convenient, Friday.
let it be on Thursday.
Lord, I give it to your lordship, whatever you say. Friday if possible not, I'll be physically here. Thursday I have some difficulty.
No.
This matter will
Not Thursday is better, Friday is the last one, we go running around. Thursday is better.
If
No, Mr. Luthra has some problem.
I have some difficulty, but I,
Thursday, we can take it in the morning hours.
but
also.
I may not be here. That's my difficulty. There was something, Lord, which was listed, which had got listed today. I've got it pushed to Thursday. That's the reason, because I didn't want to take a chance.
My lord, if my friend finishes in
Of course.
5 minutes, he can supplement it with a note. I'll finish in half an hour. Mr. Luthra gets it after.
My matter Friday and this arrangement continues.
Yes.
Of course.
Friday first hour. We'll take it on Friday.
Friday.
not at 2 o'clock.
No, no, normal course, normal.
Item 3, this hearing of this matter shall stand adjourned till Friday.
And the same understanding of not to be arrested and they'll get a deferral.
That understanding we haven't recorded.
But that's an understanding, Mr.
Yes, that, Mr.
Rohi's word is good enough.
Yes.
But I will show you page 1. That's the first judgment of the old company. To show that 17A is not retrospective and is not merely procedural. Kindly see not the first judgment of pages 3 and 4. Paragraph 6. The only difference here is that here the FIR was also prior to 17A. In my case, the FIR is later, but the offence is the same earlier, which will not make no difference. 6. In this case, the FIR filed is so and so before the provision came into force. The main question is whether 17 will apply to the investigation which had commenced before 17A was elected. This part is same as mine. I say investigation had commenced on 5th of June 18. And I showed you documents of 18, 19, 20, 21. They para 7. Cardinal principle in every statute prospect, unless by necessary implication made to a retrospective operation, there is a presumption against retrospective. An express provision should ordinarily be made to should ordinarily be made to retrospective. Now come to para 9 last 3 lines. Para 9 last 3 lines. However, a statute which not only changes the procedure, last 3 lines, not only changes the procedure, but also creates new rights or liabilities. This is what it does in my case. Is to be construed as prospective in operation unless otherwise provided expressly or impliedly. So, Lord, 17A creates new rights and liabilities apart from changing procedure and therefore, my lord, a hybrid kind of a provision. And the other side agreed and conceded in para 12. Para 12, in his usual fairness, counsel being the respondent does not doubt proposition law, the 17 does not have respect to law. The High Court had questioned the Supreme Court reversed. Now, my last point. I want to make a comment, Lord, on the judgment of Justice Joseph in the Rafael case. That is called Yeshwant Sinha's case. You also remember, Lord, we showed you that passage yesterday. Now, please note, Lord, what I'm going to. I'll paraphrase it. Originally, Lord, the writ was dismissed by a 3-judge bench. No reference was made below to 17A in that judgment. A review was filed. This is the review judgment. A review was filed. 2 judges, Justice Paul speaking for 2, dismissed the review by saying there is no ground for review. You heard everything, etc. Somebody said, you haven't argued, you haven't recorded something, you haven't done anything. And that ended it. The 3rd judge, this is Joseph, ultimately agreed with the dismissal. That's very important. He agreed with the dismissal of the review, but in the course of his discussion, he talked about 17. That will also be dismissed. I submit that will have no binding precedent. Because that is not a point which was raised either in the first instance or commented by the other 2. And the comment made by Justice Joseph that I agree with the dismissal of the review, but subject to something, has no binding precedent. And in fact, whatever the learned judge discussed, my lord, is actually also wrong. The conclusion is also wrong. Firstly, it will have no binding effect because it's only a judgment of concurrence. It is concurrent subject to something. And that subject to something, my lord, is on merits wrong, in my respectful submission. Now we go straight to Justice Joseph. Kindly, my lord, turn. My lord, the other side, I think, cited the first comment. Lord, in the other side. Lord, the other side had given this.
Yes, sir.
The compilation.
Sir, compilation 1.
In that, you also will find the first one. Yes, this is thick one. Whether it's thick.
That's a long judgment.
Yes. Lord, kindly turn to page 20. Page 20. Page 20. Your Lordship will find para 24. 2 judges dismissing the review. That is para 24. Kindly just mark that. We are of the view that review are without merit, accordingly dismissed. Once again emphasizing our judicial decision of basic authority. So two judges dismissed. Now, my lord, the third narrative starts at page 22. See, my lord, para 1 of Mr. Justice Joseph, para 33. I have approved the order prepared by Soj. While his mark, while I agree with the final decision, subject to certain aspects, kindly underline this. I would, by my separate opinion, keep my reasons. So the third that says, I agree with the final, namely dismissal, but I have some observations. That is not how I would paraphrase this part. Now, my lord, your lordship goes, come straight, my lord, to the end. Your lordship will find that page 53 of the paper book, para 115. This is the last two pages of the judgment.
That's what we are trying to say.
The outside temperature is better.
I know. Now it has become this pleasant.
Yes. You got para 115.
It is also not generated in the argument, so.
Para 115, you got. At page 389 of the report, para page 53. Petitioners. Para 115. Para 115. The petitioners have not sought the relief of preliminary inquiry being conducted, even assuming that smaller relief than one sought can be granted. There is yet another seemingly insuperable obstacle. This obstacle was 17A, which will now come first. In the year 2018, the PC Act was brought in, 17A was introduced. 17A is introduced. Then you have 117. The learned judge talks about what is 17A, there can be no inquiry, etc., etc. Kindly turn the page. Kindly turn the page. There, now see paragraph 118. Therefore, the petitioners have filed a complaint knowing fully well that 17A constitutes a bar to an inquiry unless there is approval. In fact, a request is made at least to take the first step of seeking permission in the 17. Writ petition was filed in 2018. Complaint is based on non-decision FIR. There is no challenge to 17A. Under the law as it stood, both on the date of filing the petition and even as of today, 17A continues to be in the statute book and constitutes a bar to investigation. The petitioners themselves in the complaint request to seek approval of 17A, but when it comes to relief, there was no relief claim in this behalf. Even proceeding on the basis that petitioner's complaint FIR must be registered as a disclosure of original offensive, the court must so direct. Will it not be a futile exercise having regard to 17A? I am therefore of the view that though otherwise the petitioners may have made out a case in view of Lalita Kumari, more importantly, 17 in a review petition, petitioners cannot succeed. In my view, the judgments of the review did not stand in the way, so and so from taking action. The complaint is now subject to the first respondent of taking. Now, Lord, this is what the learned judge said of his own court. He not argued, not mentioned by anybody. But Lord, I submit, not only will it not constitute any binding precedent, these are some observations. But what is more important is that the learned judge says that even if they have a case, unless 17A is out of the way, the court is also powerless. The Supreme Court is also powerless because 17A is staring the petitioners in their face. There is no challenge to 17A. But the answer is wrong because when this court is seized of a matter, even under the DSP Act, which requires the state's without consent for CBI to enter the state. Your lordships have held in the constitutional bench that powers of 226 and lordship power are not circumscribed by statute. So in a court-directed investigation,
17A can be.
simple. I'm very grateful, your lordship, to paraphrase by submission. Just as, my lord, the DSP Act cannot be a bar to your lordship jurisdiction. 17A can't be a bar when it is not ordered by a court. So the judge thought that this was an insuperable obstacle. That's the phrase of by him. So
But that question doesn't rise.
I'm just saying, the reliance on 17A here, my lord. My legal argument is, firstly, my lord, it does not constitute any ratio. Secondly, it has no binding precedent. Thirdly, the question was not raised or argued. These are just thoughts of a judge. And therefore, or otherwise also, my lord, it is wrong, because in the West Bengal judgment, it has been held, my lord, that there is no bar to a court's power. No statute can prescribe do this, do that. That's a court's power.
CPD error.
Yeah, that is, my lord, 2010, 3 SCC. It is there, my lord, in the second law, but lordship and note, my lord. It's the state of West Bengal case versus CPDR. 2010, 3 SCC, 571. Justice D.K. Jain speaking from the court. It is also, my lord, at 287 of the second
But,
compilation.
That proposition not repeat.
Now, I have a very last line I wish to make. Lord Silvai has a very interesting comment to make on this kind of situation. I want your lordship to see the entire compilation only for one line. 277.
Just 1 minute.
This is a comment of Silvai reproduced, my lord, in a judgment of this court at page 264. 264 is a judgment, my lord, of Ramesh Bhai Abhay versus State of Gujarat, 264. Act, my lord, 277. 77, para 25. I think market, my lord, it's a very interesting para. 277, para 25. Silvai in his constitutional law, para so and so explains that a decision refers to determination of each question of law, which arose and was decided. Arose and decided. In Punit Rai, the question did not arise. Moreover, there was no majority. This is
Yes.
Yeah. In Punit Rai, the question did not arise at all. Moreover, there was no majority concurrence on the question that a child inherits his caste from father. Thus, the concurring judgment of Sinha must be interpreted with reference to so and so, where the learned judge concurs with the majority of hand. The other observations in the concurring judgment cannot be seen to be. Therefore, no store can be put on a question not raised, not argued. But comes as the thoughts of a judge. The judge can give his thoughts. He gave a thought. It can be food for thought in some case.
It's now been 18 minutes, my lord.
But we are not on a time clock.
No, I am Mr. Rodgi. You may not be.
1 minute. Therefore, my lord, at the end of the day, this is not a situation which will be governed, my lord, by the observation jurisdiction.
Okay. Let us hear Mr. Salve.
Indian time, not English time.
Yes, Mr. Salve.
Yes, my lord. May I quickly take the points one by one?
So, my lord, whatever the lordship decides will be of some great significance. Yes.
My lord, what? Let's take the first point which my learned friend started with.
Okay.
Let me take the point which my learned friend started with, came to in the middle, came to towards the end, and then it closed with. Retrospectivity. But first of all, I had, my lord, in my opening, given your lordship a note, there is one case which I had missed, which explains it very well on what is retrospective. I'll not give a revised note, as my lady had said, dealing also with Mr. Rodgi's arguments, which I'll give by day after. But may I, my lord,
Yes.
give your lordship one case which explains it very well.
So we've given the citation there.
2019, 19 SCC 529.
The court master.
$20
given by.
But I believe,
Citation to the court staff.
I believe the citation has been given to the court master, my lord.
Just
You've given 3 book citations to.
Because while the book is being handed over, my lord, to save time, can I tell the court what my point is? A retrospective legislation is that which impairs past rights. Rights are between citizens and upon citizens. Between the state and the citizen, even a substantive law is considered to be retrospective if it confers new rights. And the classic example is the Probation of Offenders Act. I'll give you, your lordships have decided all this. But there is nothing substantive about 17A, apart from repeating that 17A has a substantive element. I mean, a provision is either substantive or procedural. This is like saying boiling ice. I mean, it's either ice or it's boiling. A provision is either substantive or procedural. It either operates in the procedural field or it doesn't. A right of appeal, as the very expression is a right. And unless the appellate forum is abolished, a right of appeal continues.
But yeah, clear. Yes,
But I've got an iPad. I've got the genuine iPad.
it's okay. Yes.
Secondly, my lord, my learned friend hasn't even attempted to answer the point that a provision which draws on antecedent facts in its prospective operation is not retrospective. And there are so many. My lord, this 2019 is the case where, my lord, the court examined the conflicting views about the interest to small scale industries. If the book has not available, your lordship may
No,
turn
the book
straight.
is now available.
It doesn't matter.
It's available, sir.
No, it's available.
It's available.
So it's available now.
Paragraph 63.
Page 555, Lord. Page 555.
In all the judgments, it has been held that 93 Act is not retrospective. It is not contended before us any of the parties. If the 93 Act is retrospective, the judgments, as noticed, rightly hold that the right act is not retrospective. In the opinion of Gowda J, although hold that the act is not retrospective, he holds the act retroactive. The word retroactive has been defined in blacks as follows: retroactive, extending in scope to matters that have occurred in the past. Also termed retrospective, prospective, retroact. Two-judge bench of this court in State Bank Staff Union, Madras and Union of India had occasion to examine the concept of retroactive and retrospective. In para 2021, the judgment following has been laid down. Then it's a quotation. Judicial Dictionary by I.R. Bhattavath states that retrospective and used with reference to mean affecting an existing contract or reopening up of the past closed or completed transactions, or affecting accrued rights and remedies, or affecting procedure. Words and phrases defines retrospective or retroactive law as one which takes away or impairs vested or accrued rights acquired under existing law. A retroactive law takes away or impairs vested rights acquired under existing laws and creates a new obligation, a new duty, attaches a new disability in respect of transactions. In Advanced Lexicon by Ramnath Iyer, retroactive and retrospective, then my lord, those definitions are given exactly in the same terms. If your lordship sees the foot of page 557, sorry, 556, my mistake. there is a quotation, retrospective is somewhat ambiguous. And that good deal of confusion has been caused by the fact that it is used in more senses than one. In general, however, the courts regard as retrospective any statute which operates on cases or facts coming into existence before its commencement, in the sense that it affects, even if for the future only, the character or consequences of transactions previously entered into or past conduct. That a statute is not retrospective merely because it affects existing rights, nor is it retrospective merely because a part of the requisite for its action is drawn from a time antecedent to its passing. That's the principle, which I had not put in my note. This Halsbury says it, and your lordship cite it with approval. This is the starting point. My learned friend has not even addressed Chevret's case. And rightly so, because there is no answer. The 1964 Probation of Probation of Offenders Act, in 1964, your lordships held that this would apply. This, my lord, is in compilation 3. Serial number 3. It's a judgment called Ratanlal and State of Punjab, AR 65 Supreme Court 444. I'll, my lord, only invite your lordship's attention to a specific passage. This judgment at page 50. Page 50 of the compilation. In fact, if I may read from page 49, it puts it very well. The first question is whether the High Court, acting under Section 11 of the Act, can exercise the power conferred on a court under Section 6. It is said that the jurisdiction of the High Court under 11.3. My Lord Justice Bose has it.
Yes. Yes.
Para 6. The first question is whether the High Court, acting under 11, can exercise the power conferred under 6. It is said that the jurisdiction of the High Court under 11.3 is confined only to a case that has been brought to its file by appeal or revision, and therefore it can only exercise the jurisdiction as the trial court had. And in the present case, the trial court could not have made an order under 6 of the Act, as at the time it made the order, the Act had not been extended to Gurgaon. On this assumption, the argument proceeds, the Act should not be given a retrospective operation, as if so given, it would affect criminal liability of a person for an act committed by him before the Act came into operation. In support of this contention, a number of decisions bearing on the question of retroactivity of a statute in the context of vested rights have been cited. Every law that takes away or impairs a vested right is retrospective. Every ex post facto law is necessarily retrospective. And Article 20, no person can be convicted of any offense except for a violation of the law in force at the time of the commission of the act charged as an offense, nor be subjected to a penalty greater than what might have been inflicted under the law in force at the time of the commission of the offense. But an ex post facto law, which only mollifies the rigor of a criminal law, does not fall within that said prohibition. If a particular law makes a provision to that effect, though retrospective in operation, it will be valid. The question whether such law is retrospective, and if so, to what extent, depends upon the rules of interpretation of a particular statute having regard to the well-settled principles of construction. Maxwell on interpretation summarizes so and so. The tendency of modern decisions upon the whole is to narrow materially the difference between what is a strict and a beneficial construction. All statutes are construed with a more attentive regard to the language, and criminal statutes with a more rational regard to the aim and intention of the legislature than formally. It is unquestionably right that the distinction should not be altogether erased from the judicial mind, for it's required by the spirit of our free institutions that the interpretation should be favorable to personal liberty. And this tendency is evinced in a certain reluctance to supply the defects of language or eke out the meaning of an obscure passage by strained or doubtful influences. The effect of the rule of strict construction might almost be summed up in the remark that when an equivocal word or ambiguous sentence leaves a reasonable doubt of its meaning, failing to solve out of its meaning with the canons of interpretations fail to solve, the benefit of the doubt should be given to the subject against the legislature, but it yields to the paramount rule that every statute is to be expounded according to the express manifest intention, and that all cases within the mischiefs aimed at it are, if the language permits it, to fall within its remedial influence. Let us now proceed to the present case. This is not an act which was not an offense before the act is made an offense, nor is this a case where under the act a punishment higher than that obtaining is imposed. It's an instance where neither the ingredients of the offense nor the limits of the sentence are disturbed, but a provision is helped to make reformation of an accused through the agency of the court. Even so, the statute affects an offense committed before it was extended to the area. It is therefore a post facto law and has retrospective operation. In considering the scope of such a provision, we must adopt the rule of beneficial construction enunciated by the modern trend of judicial opinion without doing violence to the provisions of the section. And then, my lord, your lordships applied this. So first of all, merely antecedent facts for procedure is not even retroactive. But even if it is ameliorative.
But Mr. Salve, one judgment was cited by
Yes.
Mr. Rohatgi, in which it has been held that 17A is not retrospective, that Justice Banerjee's judgment.
Justice Tejmal Chaudhary is the
I had dealt with in the opening. It was on common ground. Counsel said, yes, it is retrospective. And the court, 1 minute please, and the court proceeded on the premise that it is retrospective. Chevre is not cited, none of these cases are cited, none of this point is made. But my lord, factually that case is completely distinguishable because the FIR in that case.
No, otherwise, this being a coordinate bench, it will be binding for us.
My lord, I am saying if the FIR was registered prior, and this is a point her ladyship had asked me, and I said, I don't need, that's something over which both two views are possible. Once you get a 17A, do you need a 17A hop at every step, or do you need a 17A once? The standard operating procedure suggests you may need it at every stage, but maybe you don't. In that case, the FIR was prior. So if you are defeating a validly initiated inquiry, if the FIR is already registered, do you need a section 17A is a point which doesn't arise in our case. Now, my lord, coming, please don't interrupt.
Yes, Mr.
Now, my lord, so that's the point on retrospective. But the second point my learned friend made, this original package theory, my lord, I had heard it in the context of octroi. I didn't realize it applies to criminal law. Old package law, new package law, my lord, where is all this in the statute? Section 11 continues unabated, without any amendment. If you charge somebody with 11 read with 13, what are you going to do? Take half a 17A? Did they even look at the section before making this argument? Not this kind of package theory is meaningless. If either it applies to investigations for offenses post, or it applies to investigations initiated post. This original package and revised package, my lord, is, if I may use this phrase, a deeply unattractive argument. It will lead us nowhere. And my submission is, it is a check and a safeguard. And one judgment, my lord, where the union government's approach is recorded. It's in compilation 3. No. A judgment which has already been cited before, my lord, R.R. Kishore, over and over again.
Yes.
Two things, my lord.
That was page 6 of the third compilation,
Page 6 of that compilation.
which we tendered today.
If your lordship sees page 15, paragraph 29 onwards, it says for Union of India. The question was, my lord, inquiries without 6A, are they saved? And the answer your lordships gave was yes, because 6A was struck down. Therefore, it's void ab initio. But please see what the Union of India argued. Mr. Raju Learned, Additional Solicitor General, made submissions. Then, first para is that it is struck down merely because the court takes time to decide the matter, or because the challenge is made subsequently, not make an unconstitutional statutory provision legal or constitutional, even if the provision is violated. Sometimes such a violation is void ab initio, as settled in a number of cases, only rarely. In order to obviate hardship on equitable ground, court has protected in action. However, that doesn't mean the statute was not unconstitutional or bad during the period it was on the statute. Unexceptionable manner. Look at para 31, if your lordship don't mind. The prohibition under 6A is against conducting an inquiry or investigation, referring to the definition of inquiry, that is the E. In 2G, it was submitted that the inquiry commences after charge sheet is filed, is a forerunner to the trial. Reliance was placed in the case of Hardeep Singh and reference to so and so. It was further referring to the word investigation. It was submitted prohibition contained relates to the prohibition from collecting evidence in an inquiry or during an investigation. Collecting evidence. Referring to the case Subramaniam Swamy, it is submitted that there could be two situations prior to the judgment in 2014, where evidence is already gathered as part of investigation, or where evidence is not gathered because of the prohibition in 6A, placing reliance on Rishbhat, wherein, while answering the first question, the court held that the prohibition in 5.4 was mandatory in nature. While answering the second, the question held that the trial following an investigation in violation of 5.4 would not be illegal. It was submitted that where a magistrate has already taken cognizance upon an investigation without approval of 6A, the court cannot act on evidence during such investigation. The proceeding would not be vitiated in the absence of any prejudice, both actual and pleaded, with reference to the evidence. My lady was putting this to Mr. Rogi, this principle. It is further submitted that where investigation was not conducted and magistrate has not taken cognizance, the investigating agency can conduct further investigation and collect evidence, which earlier it was not able to do due to the bar of 6A. However, such investigation would now be subject to 17A of the PC Act 1988. So this is the understanding of the Union of India. It was thus submitted that after the judgment in Subramaniam Swamy, the prohibition contained in 6A having ceased, it should be with a C, misspelled. The CBI could investigate the matter subject to 17A of the Act. Wherever applicable, there would be no requirement to obtain approval under 6A. 6A does not confer any immunity from prosecution. Assuming 6A was in operation from the judgment, it could not by investigation by an agency other than those by DPSC. Reference was made so and so. Your lordships deal with that. After quoting all this, para 68, which is page 24. Your lordship says the section remained on the statute book for a period of more than 10 years, then 17A, etc. And look at para 70. It accepts the retro the submission. that the protection continues non-stop. From the above, we notice that there are small windows of couple of years and 2 occasions where there was no protection. Otherwise, right from 69, the protection regarding sanction before prosecution and remained in force and continues as such even now. So, this is not for offences committed hereafter. And this, my lord, is not concurring observations. This is a judgment of the court, a bench of 5. And I had cited this, my lord, to which your lordship have heard no answer. Second point, that's my point, my lord. So your lordship had both points of view. I can't labor this any further. I don't want to repeat. I don't think.
You are reiterating it's a retrospective. You're distinguishing.
If submit, my lord, actually calling it's retroactive. That will be the more accurate phrase.
Okay. Retroactive. Tej Mahal, you are distinguishing that in Tej Mahal the FIR was existing.
Yes, my lord.
And concession, and
And
concession.
on concession and RR Kishore.
Para 12 of Tej Mahal.
But your lordship has the point. And Justice Joseph's observations are in the same line. Whether it's a binding precedent or not, my lord, one doesn't have to go that far. I've done with this point, my lord, and I don't think saying it 6 times over is going to assist your lordship very much more.
And what is the specific point in RR Kishore you are arguing? What principle?
RR Kishore, in fact, the union government argued that all investigations are now subject to 17A, not that for offences hereafter. That was everybody's understanding.
It's kind of contemporaneous.
And the lordship, sir, except for 2 small windows, the sanction has always been, it was not your lordship's understanding that hereafter, if you commit an offence, there is a hurdle to be crossed. In fact, my lord, my learned friend has argued a point and cited authorities which are directly contrary to the point. Let me tell my lord what I mean. If 17A is not raised, suppose my client had not raised 17A, and we go on, the inquiry is concluded, evidence is brought, produced before the judge. At the end of the trial or in first appeal, I say there was no 17A, the court might say bad luck. We have the evidence. Because, my lord, we, unlike America, we don't believe in the fruit of the poison tree. Evidence even illegally gathered can be placed before a court. That's our system of law. So I must take 17A at the first instance. Now I understand in today's political context, it might be an inconvenience. That when you want elections come close and you want to fix somebody, it delays you. But that's the protection. Unless my friend goes to the extent of saying prosecuting political opponents is a vested right in a chief minister. Fortunately, he hasn't gone that far. Now, the second point, the fallacy of official duty. In fact, my lord, one of the cases my learned friend cited explains this very well. It's 197 of, let me tell my lord the point, and yes, Srinivas. One of the points is 197 applies across the board to all offences. Now, a public servant has a private life. So a question whether he is acting in official duty or not in official duty is a question which may arise. It may be apparent right on the face, or it may be a matter of investigation. The case which are cited, a police goes across into another state, barges into somebody's house, beats up people, an FIR is registered. Was he acting in the course of official duty? That itself is a matter of investigation. That is the judgment. Now, my lord, please see the observations in Srinivas, and then I will, my lord, distinguish. 17A is on a higher pedestal.
First compilation.
If one is using the analogy of civil construction.
State's first compilation.
The state's first compilation, my learned friend cited a case called A. Srinivas Reddy and Rakesh Sharma. That police.
Police is not.
Here was not a bank official who was fiddling. Which, Manoj, your lordships have the page 243.
Volume 1. Page 243.
There is that compilation.
Page. It's A. Srinivas Reddy, 243.
Yes.
State Volume 1, A. Srinivas Reddy, by Lord Justice Gawain, Justice Pardiwala.
This was not a case of a bank official of State Bank. Now, by an extension, your lordships have held that bank officials of this, including private banks, are public servants. Judgment may have to be considered someday. Now, FIR is lodged for his helping somebody virtually steal money from the bank by approving loans, etc. I mean, without the PC Act itself, he would have gone in. But my lord, what your lordships say at para 61 is extremely instructive. And that is at page 262. It says, thus, although in the present case the appellant has been discharged from offences under PC Act for the IPC offences, he can be proceeded further in accordance with law. From the aforesaid, it can be said there is no thumb rule that in a prosecution before the court of a special judge, the previous sanction under 19 would invariably be the only prerequisite. If the offences on the charge of which the public servant is expected to be put on trial include offences other than those punishable under the IPC, that is to say, under the general law, the court is bound to examine at the time of cognizance and also, if necessary, at the subsequent stages as the case progresses, as to whether there is a necessity of sanction under 197. There is a material difference between the statutory requirements of section 19 on the one hand and section 197 on the other. In the prosecution for the offences exclusively under the PC Act, sanction is mandatory with the public servant. In the cases under the general penal law against the public servant, the necessity or otherwise of sanction under 197 of the CRP depends on factual aspects. The test in the latter case is of the nexus between the act of commission or omission and the official duty of the public servant. To commit an offense punishable under a law can never be the part of an official duty of a public servant. It is too simplistic to approach and adopt and reject the necessity of sanction under 197 on such reasoning. The safe and sure test is to ascertain if the omission or neglect to commit the act complained of would have made the public servant answerable to the charge of dereliction of his official duty. He may have acted in excess of duty, but there is a reasonable connection between the act and performance. The protective umbrella of 197 cannot be denied. So, my lord, 19 is inevitable because you are applying the Prevention of Corruption Act. Look at, my lord, how absurd the state's position is. If the state's argument is to be accepted, then it is only innocent people who are protected by 17A. So you must first conduct the full inquiry. If you establish that he had acted corruptly, then 17A doesn't apply. If you establish that he was honest, then you will go to the governor and take what permission? Permission to not prosecute him. They turn the section on its head. Please see para 62 also. Before we close this matter, we would like to observe something which this court may have to consider sooner or later. The object of 19 is to protect public servants from frivolous prosecutions. Take a case where the sanctioning authority at the time of declining observe sanction is being declined because the prosecution could be termed frivolous or vexatious. In such circumstances, what would be its effect on the trial so far as the IPC offences are concerned? Could it be said that the prosecution under the PC Act is frivolous, but the same would not be so for the offences under IPC? We are not going into this question because the present matter, as sanction, was initially not declined, etc., etc. Now, but apply this to our case. What if they go to the sanctioning authority and he says, not me, the sanctioning authority says, all this is so much blah blah in your counter affidavit. Because you cherry-picked documents and you made people make statements, junior officials, and made it look like a huge big case. Sanctioning authority can not go into the details and come to the conclusion, sorry, you're fixing a political opponent. He may take the view or he may take the view this is a good case of prosecution. So, my lord, this is a very important aspect. 17A, if your lordship turns to the statute.
7 minutes. 7 minutes.
Yeah, I'll finish. Almost done. Section 17A. And my learned friend said, I have not pointed out the errors in the impugned judgment. These are the two mistakes the learned judge makes. He first says this applies only to past offences, only to future offences, not to past. And the second thing he says is official act not shown. Look at the language of 17A. No police officer shall conduct an inquiry or investigation into any offence alleged to have been committed. Please mark the words alleged to have been committed. My learned friend says, let me finish the inquiry, then you decide whether 17A is required. Where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties. And I had not shown your lordship the remand application and the counter affidavit are littered with allegations. He decided, he released, he did this, he did that. The legislature now has been very careful. Legislature now has been very careful in drafting this section. So this official duty, not official duty, now is in a context. Decisions made or recommendations made by such public servant in discharge of his official duty. Now, if you say acting corruptly is not a part of official duty, then 197 principle is injected here. It will then mean that if you are innocent, then 17A comes in. But if you are guilty, 17A doesn't come in. It's turning the section on its head. I'm done with this point. If I'm wrong, it's all right. But if I'm right, where are we? I had made 2 points, my lord. First of all, there is a composite charge sheet, and I had cited those cases to which there has been no answer. Ancillary charges versus standalone charges. And where it is ancillary charges, and I only drew inspiration from your lordship's judgments in Tata, saying the whole thing goes bag and baggage. Here, my lord, your lordship will not be able to pick the green from the blue straws if your lordships go through the remand application of which is an offence under the PC Act and which is an offence outside the PC Act. So this kind of a rumbled up argument saying there are charges here and charges there don't get you anywhere. So the whole thing goes. The second and the more important thing is there are a litany of public servants and there is not one single 17A. If all the public servants go out, there is not one single judgment, my learned friend has cited, that you can walk up to a special court without a public servant and get him to take cognizance. The special court will tell you, get out of here, go to the magistrate. So, my lord, today you are in a situation, if there are 5 public servants, for none of whom you have the right to investigate. You've gone against a group of private people for stealing money from the government and doing GST offenses, and you walk into a sessions judge, he will send you packing to a magistrate. What my learned friend has shown are cases, and my lord, I don't even need to read them, your lordships know. If at the end of the day, because the words in 4.3 are, he has the jurisdiction to try a case, not to convict. So if at the stage of trial, he has jurisdiction that the conviction may end only with IPC offenses. I have never disputed that proposition. Nobody can. But today, my lord, we are at an ancillary stage. At the very inception, which is my learned friend's grievance. Why don't you wait few more days in custody? Only 40 days. Wait for another 60, 70 days at least. Let us get some political mileage, then you come out. But my lord, my respectful submission is, therefore, to close this point, today, if there is no 17A for a single public servant, everything goes. The order, and my learned friend, I was a little surprised when he said, there is no court involved today. The court has passed an order.
Not challenged so far.
Sorry?
Others are not challenged so far.
Others may not have challenged,
Yes,
but
not-
in my case, that's what I'm saying. In my case today, if you are purely based on this, you are not taking him on the basis that he's a private person. You are alleging PC. Where is the question of the court should have said, where is your 17A? The court should have asked him for 17A. Now, my learned friend to which he said, we are only concerned with an FIR. We are not concerned with the court. Somewhere along the line in his eloquence, he forgot. We are not concerned with the FIR. There is no mention of Chandrababu Naidu in the FIR. He was added by the remand. And the remand was an application to a court. And it was done by order of the court. He says, where is the court? There is a court.
There is a reference of.
No, not in this FIR,
No,
leadership.
not in the FIR.
Not in this FIR. That's your leadership, that's the other one. That's the AB you put on Friday. Here, there is no.
That's another case.
Okay.
In this accused 37 was added by the remand memo,
sir.
which I will not read at quite some length. So, my lord, this is the short answer to all his points. But let me assume I am wrong. In any case, 17A stands in the way. And you've got all these orders from the court based on 17A. These orders must go. So, my lord, that is the submission. If the remand order goes, then the man has to be set at liberty. Now, my lord, I've concluded, and unless there's anything else I can assist the court with, I will put in a note dealing with all the points.
Both the sides, brief note of submissions.
Only one
So that now I have only one request to make. I take it your lordship will
One request to Mr.
have to
Salvi.
decide this case. My lord, the man has been inside for 40 days. I have a request for interim bail.
73.
Prayer is there.
73 years old. Your lordship can consider releasing him.
Medical condition.
Examine.
We have heard the main matter from.
But main bail was instead day after tomorrow before the.
No, that's not on 17A.
No, that's,
On
that's,
17A, your lordships have heard.
Same FIR,
I'm
main.
only making a prayer. Please give him interim bail. If your lordship sold 17A against him, he can go back in. That's my request.
I just clarify. That's not on 17A. Please see page 90. The prayer is there.
Same offense.
Just a
same-
minute, sir, please. I can ask for 167.2 and regular bail at the same time. Here we are, please see page 90. We made a specific prayer.
We've heard the main matter, we'll deliver the judgment. Yes.
Very good.
Only one factual clarification.
Lord, he's
An
just
FIR
in
is
custody,
fine.
Lord.
If any person is
40
to be
odd days,
acted
not
as an
since 9th.
accused in the FIR, but because under 156, 157, it is subject to the magisterial control. But when we are adding a person to the FIR, a memo will be filed into the court saying that we are now adding some more people as accused to the FIR.
Yes.
It is not by virtue of a threat.
no, my impression was that his name was already there.
No, it's not
No,
there.
it is not there.
Added a memo.
Right.
The practice,
But not
practice is
not a court order or court permission. It is done by the investigating agency, but by informing the.
I'm sorry, my lord, one sentence, just one more sentence. I missed one point in my anxiety to finish quickly.
Report to the magistrate. and thereafter it continues under the
Now,
magistrate.
please allow me to finish.
Survey might bear, may not is time. Because inside we are not in-
Allow me to finish, please. You have taken enough time.
I'm addressing the honorable court, but I'm
Salve
making
saying
one
something.
submission.
He has some
But
argument.
once 154 is filed, the minute report will have to be forwarded to the magistrate.
It's not by way of demand application that you ask somebody. So that's a-
But I thought the state was complaining about relay races anyway. But I just wanted to add one more sentence. On the 2016 inquiry initiation, 2015, 2016, I had given your lordship the page numbers. The government's lament was nothing came of it. If nothing came of it and you started in 2021, it's a straw in the wind, which you're desperately clasping to by referring to that inquiry. That's my short answer.
Okay, thank you.
Deeply obliged, my lord. Deeply obliged.
Submissions, your lordships are giving 2 days.
2 days.
By Friday,
Hearing concluded.
before Friday, by Friday morning.
By Friday, we will not.
By Friday, do it by Friday.
We do it by Friday.
See all these notes.
If we could give the written submissions in a day or two,
Yes,
Your lordship.
By Thursday.
My friend will give first, will not. Then.
no, it's.
No, it's sequential, please. This is not ping pong.
Friend is saying in 1 day, 2 days advance.
Thursday.
No, it does, because then we have 1 week vacation.
Also, we'll give
And
it.
the man is in jail.
We'll give it by Friday, I am saying.
Give it by Friday.
What can give by Friday?
Lordship, please.
Not-
Okay, report.
Bail petition will be considered on its own merit in the bail application.
Lord, I'm sorry, Lord, I think this is a
Petition is not a
fallacy.
bail petition.
But may I just say this, there's a fallacy here, and I must clarify if Mr. Salve permits me, sir, if I may. We had argued in the High Court based on Arnab Goswami saying that in Washington you can release. Before the trial court, we had moved an application as in the High Court that we are arguing this irrespective of 17 capital A, which is being argued in the High Court and Supreme Court at various stages. We never closed our right to seek release in 17A. I'm sorry to say this, they're totally, my learned friend who argued it in the trial court is here, Mr. Dubey. He did not touch 17A because he said that matters subject to adjudication of the court. And we are saying that if the remand goes, release has to follow. If we are successful, that's what we are
But
saying.
what was argued was that the Supreme Court has so much power that it can pass any judgment in the 480.
It's not like that.
And
At least I hope now the state of Andhra won't complain about relay races.
Anyway, we've heard the matter.
And Niharika, your lordship said
That
it
was
is not
not-
about bail and.
There you are.
Interim orders.
Niharika is now,
Anyway, Arnab Goswami was before
clarified.
Niharika.
but now.
I think your lordships have heard enough of this matter now.
Yes.
Yeah, enough of this matter, no problem.
Okay.
You are.
Great.
Therefore, I am happy to answer. Lordship is very good.
Thank you.
ये सारी दे देना जरा सब दे देना हाँ close it from the cross at the top.
Yeah.
Like to close first, you close this dialogue log cancel.
Leave me.
नहीं हो रहा, meeting नहीं हो रहा.
हो जाएगा वो हासिल तो करा हो जाएगा. It will happen.
Papila. ఆ ఫ్యాన్ ఆపేసేళ్ళు ఆ ఫ్యాన్ ఆపే సైలెంట్గా ఉండు వెళ్ళిపోండి బయటికి వెళ్ళిపోండి అరా మాకు శుక్రవారానికి వాయిదా వేసారండి శుక్రవారం బెయిల్ పిటిషన్ ఫస్ట్ దీని మీద కూడా వాదనలో ఆ రోజే ఆర్గ్యుమెంట్స్ ఆ రోజే తీర్పిస్తామని చెప్పి ఆర్డర్స్ ఇస్తామని చెప్పి చెప్పారు జడ్జీలు కాబట్టి చూడాలి మరి ఏమవుతుందో